This honorable court is in executive session.
May be seated. All right, we're here for our second matter. It's State versus Marshall. I want to ask counsel for their appearances for two reasons: to identify themselves and also to make sure that our audio is working in all respects. So first, as to our virtual participant, can you hear me?
I can, Your Honor. Thank you.
Perfect, and we can hear you, so that's all great. Can we have counsel's appearance, please?
Hannah Levitt Howell for Mr. Marshall, Your Honor.
Natalie Edmondson for the state.
Very good. I see 12 minutes on the clock. Does that mean you're reserving 3?
It does, Your Honor.
Now, this awkward thing, I've explained this before. We all have you on our screens to the right, so typically we're gonna turn our heads to the right, but I understand the camera's looking at me, so it looks like we're not looking at you, but it's just the way it rolls, so as long as we're all comfortable with that, we're not paying attention. As long as we're clear with that, you may proceed.
Thank you. Your Honors, Mr. Marshall raises two issues on appeal. First, the trial court erred when it granted the state's motion to hold the trial in absentia. And second, Mr. Marshall received ineffective assistance when trial counsel failed to object to Sergeant's testimony that Mr. Marshall had the intent to distribute drugs. Moving to the first point, the trial court erred when it granted the state's motion to proceed in absentia because the state failed to make any attempt to show that Damon was voluntarily absent. And to the contrary, the evidence in the record suggests that Damon was in fact involuntarily absent.
I mean, there is record of some attempt. I mean, the court tells us that during that half-hour gap, I can't remember the phrase it used, that it put word out through the courthouse, right?
Yes, Your Honor, it does say that.
And so if Winozik says that the constitutional obligation, quote, requires some form of inquiry by the trial court, and we don't have a case that's really spelled out a checklist of you must do this, this, and this, and you've got the court putting out feelers within the courthouse for a half hour, why isn't that, quote, some form of inquiry?
Yes, Your Honor. So I think the issue here is that there isn't a checklist per se, but there is a number of things in Winozik and other cases that suggest what an adequate inquiry might be. And that adequate inquiry does seem to include some pretty basic elements like checking hospitals, seeing if the defendant's incarcerated, and having the defense attorney call the defendant. And so, I mean, asking around the courtroom, the courthouse.
Do we have a, not, sorry to cut you off, but do we have a case that says that any of the things you just identified are actually required to constitute an adequate inquiry?
No, Your Honor. They don't say that it's a required checklist, but we do know in Winozik that simply having the defense counsel call the defendant was not enough. And then it specifically cited some of these other things might be required, like a really basic search to see if he's incarcerated or in the hospital. And so I think, and it's really those two things that are repeated over and over, with the idea being that we would like to make sure that a defendant has made a choice, a conscious choice, to not be at a trial before we violate their Sixth Amendment rights. And here, we know for a fact that defense counsel did not call Mr. Marshall because defense counsel told the court later on at the end of trial, and presumably before trial as well, that he didn't have his cell phone, that he didn't bring his cell phone. So there was no way of knowing if Mr. Marshall had called defense counsel, and there's certainly, it was impossible then for defense counsel to have called Mr. Marshall. And I think it's useful to read the rest of what happens on that first page of the trial. It's 351, right? He's put out word, and then the state is given the opportunity to present a motion. And the motion in its entirety is, Your Honor, it's our motion to proceed in absentia. We think he's voluntarily decided not to appear today, so it's our motion to go forward with the case. And then when the defense counsel says there's no evidence that he has voluntarily chosen not to appear, the state doesn't say anything. The state doesn't try to say, no, there is evidence. We've done our minimum inquiry. And when called out on that, the court says, we'll sort through that later, right? The court doesn't make a finding that Mr. Marshall had voluntarily absented himself, and instead said, I don't think this is important. Let's move forward so that we don't inconvenience the jury. And that was incorrect.
One of the things the state tells us in its brief is that the defendant had failed to appear for other proceedings and hearings as well. Is that right?
As far as I know, Your Honor, the only one that he was late to voir dire. I don't know that he was absent at other hearings in this trial, but we do know from sentencing that he had perhaps been absent at other proceedings in other trials.
Do you think it's appropriate either at the inquiry stage or at the prejudice stage for a court to take into account whether this particular defendant has missed or been late to prior proceedings?
Yes, Your Honor, I think Winosek makes, I believe it's Winosek, but it might be Gunter, that says it would be inappropriate to apply an automatic presumption of voluntariness based on nothing more than non-appearance at past hearings. It's Winosek, paragraph 15.
But even if it's not an automatic presumption, can at least be taken into account? I mean, can a court say, as part of its sort of discussion with counsel about this, look, he hasn't appeared 5 times. I know that's not this case, but he hasn't appeared 5 times. So that seems to suggest it's not an automatic presumption, but I'm going to take that into account. Is that appropriate, or do you think even that would be too far?
I think that would be too far unless there was more context, right? If the defendant was walking to the courthouse and was late every day and he knew exactly how long it took to walk to the courthouse, then that maybe looks like more of a conscious choice. I think the problem there, right, with the idea of why that automatic presumption is problematic is we need to be looking at conscious choices.
I don't want to put words in Judge Tenney's
No,
mouth,
feel free.
but I don't think he was talking about an automatic presumption.
Y-
I think he was talking about whether on harmlessness or on the factual finding of voluntariness, the court can take into account past no-shows.
That's right.
Or late shows.
Yeah.
Not that results in a presumption, but I think the fundamental part of the question was, can the court do that? For example, in this case, had the court done other things, but one of the things it did was on the record say, when confronted with this issue, the judge could have said, my recollection in this case, kind of a judicial notice kind of thing, my recollection is on this case that this defendant has missed or been late to whatever proceedings the record shows, and if neither the state nor defense counsel corrects the court can infer from that we at least have a history of tardiness or no showing. That would be appropriate, right?
Just to make sure I understand, Your Honor, I think that the standard is that the court needs to conduct an inquiry. Whether or not repeated absences are relevant for that inquiry would depend on
That's
whether
the
those
question.
repeated absences had been voluntary in the past. But if he was involuntarily absent 5 times previous, that doesn't matter if he's involuntarily absent again.
Okay.
Thank
your
you.
answer.
And as to the prejudice question, it could, I think the issue here is that we have a presumption of prejudice if there was an involuntarily.
Can I ask you a sort of a 1,000-foot prejudice question? I take it from your reply brief that you're not arguing that this is structural error. Do I have that right?
Yes, Your Honor.
Okay, so if it's not structural error, one of the things, both briefs grapple with it, and to be honest, I'm still working through it. Is our prejudice inquiry here about whether the district court, if it had conducted the proper inquiry, would have found him to be voluntarily absent? Or does it also take into account whether it would have made a difference if he'd been there all along, or is it both? I mean, what my question was really about is that second piece part of this.
I'm not sure I understand what you mean by the second piece. Part of this.
As part of, like, let's suppose we agree with you that the court did not conduct an adequate inquiry. In terms of assessing prejudice, are we only trying to figure out whether the motion to absentia should have been granted? Or are we also allowed to consider whether we think his presence at trial from minute 1 would have mattered?
Right.
That's what I'm
So,
asking.
thanks. I think that's a complicated question that the case law isn't entirely clear about. I do think Gunter says the state can show harmlessness by showing that if an adequate inquiry had been conducted, the result would have been the same. So if the converse of that is true, that means that the state cannot show harmlessness if an adequate inquiry would have shown that that it was an involuntary absence. So that's Gunter. That could be taken at face value. I think there are some problems with Gunter, in fairness, specifically that Gunter doesn't really grapple with the constitutional aspect of this. So perhaps the better inquiry would come from Chadwick, and Chadwick says that the state cannot rebut the harmlessness cannot show that the error was harmless beyond a reasonable doubt if it can't show that the sentence or the verdict was not, I'm sorry, I've done too many negatives. If the sentence or the verdict was affected by the absence, right, by the constitutional error.
Yeah, I mean, let me just create the sort of, I know it's the extreme hypothetical, but this sort of gets at the problem that I'm trying to figure out, which I think you just said is the case law is unclear, and I think that's right. Let's suppose you've got a defendant who's caught on video committing the crime and insists on his right to trial, as this is constitutional right, and then he doesn't show up until midway through the trial, right? There's no universe where he's gonna be acquitted, we've got him on video, he's committing the crime. What are we doing on the prejudice end of things if the court doesn't do any inquiry? Are we looking at it and saying, well, his presence wasn't going to change a thing, therefore there's no prejudice? Or are we confined to, did the court conduct the proper inquiry and properly determine whether he was voluntarily absent? That's what I'm trying to figure out.
Right, Your Honor, and I wish I had more concrete examples from case law. I will say that different states handle this differently, and as far as my research went, as far as my understanding is, to say that it doesn't matter at all whether the jury could find him innocent based on the evidence, that looks more like structural error to me.
Yeah.
And I haven't been able to find a state that views this as structural error. I do think there are some states that get closer to that, and, right, Utah seems to be hinting at that in Gunter, saying that the outcome of the voluntariness inquiry is what really matters. But either way, in this case, the state can't show that it was harmless beyond a reasonable doubt because the court was clearly affected by it, right? I mean, for two reasons, I guess, right? I think the sentencing was affected. We have the quote, let me just read what the court says exactly. The court says, after asking why he was late, the court says, so the problem I'm having is it sounds like you're relying on an inherently unreliable car. That's on 451. And then on 453 says, my biggest problem is this is a pretty big deal today. I mean, you've been charged with a first-degree felony and you showed up half an hour late to your own trial on a first-degree felony before deciding to take him into custody. The court then also makes a number of comments saying, at this point, I tend to agree with the state, there's going to be minimal, if not more, time that he's going to serve, indicating that it's perhaps because of this tardiness, and then also references in sentencing the fact that Mr. Marshall had an attendance problem when declining to give Mr. Marshall the opportunity to go to probation or some sort of drug treatment program. So, I mean, all of those statements would suggest that the sentence obtained was affected by the decision to move on with trial without Mr. Marshall present. Beyond that, I think it was possible for the jury in this case to conclude that Mr. Marshall Mr. Marshall was guilty of simple possession instead of intent to distribute based on the evidence. And there are a number of reasons for that. First, the sergeant himself indicated that there were rational reasons why someone would buy drugs in bulk. First, it was cheaper. Second, right, it also seems like it could be safer to have a single transaction instead of multiple transactions. The evidence suggests that Mr. Marshall was pulled over directly from leaving the drug house that was under surveillance, which would mean he had no time to repackage the drugs. So the packaging wasn't necessarily Mr. Marshall's choice, it's just how it was given to him. And then also importantly, when Mr. Marshall was pulled over, there were no other objects found that would support the idea that he was dealing drugs, like scales, extra baggies, excess cash, clever like cans where you can hide the drugs, right? All of those are common items in drug distribution cases. So there was in some, the case.
I think you're, just as long as you're cognizant of it, you're headed into your rebuttal time.
Thank you, Your
If
Honor.
you
I was
want.
not cognizant of it, so I
All right.
appreciate you pointing it out. I would just wrap up by saying the trial court erred. The state did not prove that Mr. Marshall was voluntarily absent, and we would ask this court to reverse. Thank you.
Thank you. We will turn to the state.
May it please the court, Natalie Edmondson for the state. Starting with the in absentia issue, there are two procedural reasons that the defendant's in absentia claim fails here. One is an inadequate record, and the second is a waiver of his in absentia arguments in the trial court. Starting with the inadequate record, as this court has pointed out, there was indication of an off-the-record conversation prior to the court coming onto the record at 9:30, indicating.
If we write an opinion that says it's your burden, the state's burden, to establish voluntariness for in absentia purposes, does the lack of record then cut against you?
Yeah, I think that would just be incorrect, given the case law that talks about the inadequate record, how that plays into appeal, because the burden, when the defendant is appealing an issue, he carries the burden on the appeal. So while in the trial court, the burden's on the state to show a voluntary absence, once the defendant is appealing that error, the burden shifts to him to prove the error and how the error affected him. And we have Rule 11 of appellate procedure talking about if an appellant is appealing like in order, that they need to get the records that are critical, that are in support of that order, and it's not the appellee's burden to be able to do that.
What do we do here with the court's ultimate order? That's what we'll call it, I guess. It's ruling. That was on the record, right? Are you saying that the court's ruling was also not part of the record? It seems like the court was saying, the court on the record says, I'm going to grant the motion. When he appears, we'll get to the bottom of it. We've already got the jury here, which I frankly think is a large, having been a trial court judge, you have a certain momentum. You've got a jury sitting here that are all looking at you. And having a continuance to wait for somebody to show up is awkward, to say the least. But as our case law indicates, as awkward as that is, that might be necessary. All the cases seem to say that. And he says, we're gonna cross that bridge when we get there. Are you saying there's something in the ruling that's outside the record? Not the discussion as to what constitutes voluntariness or not, but are you saying there's reason to believe that the court expanded on that ruling?
Expanded off the record?
Yeah.
Well, I guess the short answer is we really don't know, because we just don't know what happened off the record.
We can't rely on what the court said on the record?
I think you can definitely take that into consideration.
Because the court does not make a finding of voluntariness at that point.
Not explicitly. I think it's implied, because the state is asking to move forward in absentia, saying we think that the defendant has voluntarily absented himself. So I think, the trial court doesn't explicitly say, I find the defendant has voluntarily absented himself, so we're going to proceed.
Do you think trial court should do that?
I think that would be best practice, to also put the reasons why on the record. But where it's not on the record and the defendant's appealing it, ultimately it's his burden to either, make sure that that's a part of the record somehow, even if it's trying to recollect, re-put together, reconstruct the record essentially. And so where that doesn't happen here, we don't know what happened, and there was an opportunity for this conversation to occur over 30 minutes, right? So there could have been a lot more done than we know, and we know that some things were done because we know that the court at least put word out through the courthouse to see if the defendant called in.
I take your point about the appellant's obligation to create the adequate record, but on the other hand, I think what they're telling us is it would be a little bit curious if somebody had tried calling him, or if somebody had tried checking the jails or the hospitals or so forth, for somebody at that moment where the court comes on the record and kind of announces its decision, for somebody to have not said, we tried calling him and he didn't answer. There's something a little bit odd about that. Human instinct is somebody would have said that. We tried, we couldn't.
Sure, I think that's fair. I think, like I said, best practice would to restate, any reasons on the record of, they could have made, an extensive argument off the record, and then when they came back on, they just summarized it for, the record. But I think best practice would probably be to explain the reasons why, but I don't think that means that it didn't happen here just because there was a summary on the record. And the second reason.
Let's suppose we get past the record problem. Why wouldn't we go ahead and write an opinion just to sort of create some clarity for the law? We've got this phrase from Winozik that there needs to be, quote, some form of inquiry, it seems like we don't have a lot of case law on this. It seems from the briefing in this case alone, like there's some confusion about what is or is not required. Why wouldn't, just to sort of give guidance to the trial bench moving forward, we write an opinion saying something along the lines of, at a minimum, that some form of inquiry contemplated by Winoza includes calling the defendant, checking the hospitals, checking the jail. So
Sure.
would that be problematic or no?
Well, I think that, the court's kind of already been through that, that reasoning already, because in Wanasek 1, the Court of Appeals tried to outline various, things for the trial court or the prosecutor or defense counsel to do. Gave like half a dozen, inquiries or possibilities for inquiries. And then we have Wanasek 2, saying, that's really not necessary because a proper inquiry really might vary case by case and what the trial court knows, in any given case. And so Wanasek 2 says it's in the trial court's, hands to kind of determine what is a proper inquiry in any given case. But we have some guidance that is, at minimum, Wanasek 2 mentions that counsel try to contact the defendant or people who know the defendant, and that the state, might also inquire into incarceration.
Do you really read paragraph 15 from Wanasek 2 as distancing themselves all that much from what the Court of Appeals said in Wanasek 1?
Yeah, I think.
Paragraph, well, go ahead.
Yeah,
If
I
you
think.
understand what I'm talking about.
I do, and and again, they're talking about how voluntariness is highly fact dependent, the court is gonna be, it says the trial courts are well positioned to assess what questions need to be asked and answered. And then it talks about, it gives specifically the contact with hospitals. It says, the contact with hospitals, however, another avenue mentioned by the Court of Appeals would seem unwarranted unless there was some specific reason to the case. So I think that's just all to
But
say.
then they go on and they say, in the average case.
Yes.
This is where the trial court, well, first off, backing up, they said, the prosecution, which must bear the burden of proof regarding waiver, would be well served to assist the court in its inquiry by providing at least some minimal evidence that the defendant is not incarcerated. I think that's a very eloquent sentence to say, can't you just turn to the deputy to your right in the courtroom and say, hey, will you call it jail and see if he's there? I mean, as a district judge, I only did that maybe 100 times. Because people didn't show up, and it's like, but they're frequent flyers, for want of a better term.
Sure.
And so you're wondering whether they were at the jail, and often they were. They say in the average case, the trial court may simply instruct defense counsel to attempt to contact the defendant. We have no record evidence. I understand your previous point, is that's the other side's fault, not yours. But what we have is the lawyer saying, I didn't bring my cell phone to court today. What we don't have is the court saying, oh, shoot, my clerk has a phone on her desk there, why don't you try calling him? It seems that the Supreme Court was, while not really excited about this idea of contacting the hospitals, didn't think it was too big of an ask to have defense counsel try to call his client on the phone.
Sure, yeah, and again, that's why Wanasek 2, mentions this, kind of some inquiry and suggests these kind of minimal things. And I think it could happen, and putting this out in our brief, that maybe off the record, right, maybe there's some other opportunity, like, again, we don't know if counsel had access to his computer and emails. If he could have borrowed the court's phone, he just seems to say, well, I didn't want my phone to distract me, so I didn't bring it, so I can't call him. And I think what's also notable is when the defendant does appear post-trial, he's giving this explanation. He never claims, I tried to call my attorney, I tried to call the court to let you guys know I was gonna
Why
be
didn't the
late.
state ask him?
Why didn't the state ask him at that?
Yeah, did you try to call?
Well, because the court put kind of the ball in his court and said, hey, give us a reason on why you didn't show up today. And he has the opportunity to explain it, but never claims to, claim to call the court.
Is it a fair characterization that this post-trial conversation was more about whether he should go to jail today than about whether he missed the trial?
Yeah, that's definitely the context. But I think, it still demonstrates facts that go to why he wasn't there, which ultimately goes to the voluntariness question.
I assume you would argue, because you told me that at the time the court decided to move forward, it did not make an express finding of voluntary absence, but that was implicit. it doesn't appear that post-trial the court actually makes a finding as to voluntariness either, but are you
That's right.
claiming that's implicit there as well? Or
I think, I mean, maybe,
does the
other,
court ever make an express finding of voluntariness?
no, I don't believe the court does. But part of this goes to, a waiver of the arguments in the trial court, because when the defendant does show up, he shows up mid-trial, and when he does show up, the court calls parties forward to a sidebar to say, hey, I think your client's here, how do you want to proceed? And so counsel just decides to bring him forward and continue a trial. There's no request for a recess. There was no, to even confer with his client about, hey, why were you
Are
late?
you saying that shifted the state's burden to prove voluntariness for that part which he had missed, or for?
Yeah, I
moving
think
forward?
at that point, yeah, the burden would be on the defendant to show.
Do you have a case that
involuntariness.
supports that?
I think that Wanasik 1 and a little bit of Gunter get at that, and that's just because the way that they frame the prejudice standard. So Wanasik 1,
Well, I'm sorry. I thought my question was going to the voluntariness
It-
of absence, not the prejudice.
yeah,
Those are
it is.
separate things, right?
They are, but Wanasik 1 kind of combines them. And so what I'm trying to get at there is that Wanasik 1 puts the burden on the defendant to prove prejudice when challenging the trial court's inquiry. So I think that would contemplate a scenario where the defendant shows up, he knows the reasons why he wasn't there, and then he chooses not to tell the court that. And the important part about that is that there are remedies that are available to him in that moment. And when he chooses not to, avail himself of any of those, continues to go forward with trial, but then decides to raise it on appeal, I think that's problematic because the trial court had the opportunity to try to fix it in the moment. And, the defendant decided not to take that opportunity to, request any other remedies there.
Let me ask a question, give you
Yeah.
drinking time. Suppose we get through the various arguments we've made so far, and we get to the question of voluntariness, and suppose that we sort of accept the invitation to take what the district court said at sentencing and graft it back onto the voluntariness question, which the briefing has sort of gotten at it a little bit. The district court, if I'm reading the comments made at sentencing correctly, the district court seems to have faulted him for his car trouble. And what we're hearing from the other side is, it's true that he had car trouble a week earlier, but he's now saying on the record that he fixed it, and he's got new car trouble. And the district court just doesn't seem to think that matters. I think the court's verbiage is a little bit fuzzy, but
Yeah.
what I think I'm reading the district court is saying is, that just doesn't matter because what matters is you knew that your car wasn't great and you should have just gotten a ride with your son. And I take the point on sort of a pragmatic, practical level, but then the flip side of that is you've got a lot of people who don't have a lot of means and they have unreliable cars. And if we're going to say that if you don't have a newish car, that it's on you, that there's something a little classist about that and that there's something really problematic. And that resonated with me a little bit. I'm wondering if you think it's appropriate for us to sort of adopt the district court's worldview here in terms of people who have less than great cars, right? What do we do with that?
Yeah, so I think, so the case law makes clear that voluntariness is highly fact-dependent. It's going to turn on the totality of the circumstances. And so, Marshall makes these policy arguments in his brief about this. But this court isn't, it wouldn't be required to kind of make a blanket conclusion that any sort of like car problems or anything like that is going to automatically mean you're voluntarily absent. I think it's important to look at the specific facts of each case, the circumstances, what the defendant knew, and the choices that he made with the knowledge that he had. And here, that demonstrates a voluntary absence, and I have a couple points why.
Yeah,
One was that he was late to jury selection a week before for the exact same reason, car problems. He mentioned he had bought the car a week before and said it had problems staying running, which indicates a continuing problem. He acknowledged that even though he thought he had fixed the problem, there was a solenoid that needed replaced, but that he didn't have the means for that. And then he said that he asked his son if the car is not willing to stay running, if his son would give him a ride, clearly foreseeing like, hey, this might be a problem. In the event that it is, could you help me out, right? And then he said that his son was willing to help him, but he wanted to be able to come up on his own. So again, he's making these voluntary choices. And what's more is that he used the code reader on the side of the road, which I think indicates no rush to get to trial. In fact, in the defendant's opening brief, he states that when the car broke down on his way to court, he attempted to fix the car, and when he was unable to do so, arranged a ride with his son. And that's at Appellate Brief 17. So this is indicating that he's really in no rush to get to court, even though he knows it's about to start. And again, there's no indication that he called to say, hey, I'm having these problems, please hold off, I'm on my way, right? So that all, I think, demonstrates, all the circumstances demonstrates that he was, and I think the Court of Appeals in Miller, Idaho Court of Appeals in Miller put this aptly, is that the defendant took a calculated risk in relying on a vehicle that had proven to be unreliable. So it comes down to voluntary choices, and that's what happened here.
You're at zeros, but I've got
I am.
questions on prejudice. Can
Please.
we go there unless you want to stay on voluntariness? Okay, thank you. You heard the discussion that I had with Ms. Levitt, Howe about this.
Yeah.
In terms of figuring out prejudice, are we looking at whether the district court would have found it to be voluntary if it had conducted the inquiry? Are we looking at whether his presence would have mattered, or are we looking at both?
Yeah, and it is a little unclear, but I think, so Wanasik one, again, put the burden on the defendant to prove prejudice when challenging the trial court's inquiry. And so I think in that way, because the inquiry itself isn't the constitutional error. So harmless beyond a reasonable doubt only comes into play if there is a constitutional error. The inquiry alone isn't the constitutional error. It's more of like I think about it in terms of Miranda, like a prophylactic
Right.
rule meant to safeguard
I agree with that.
the right. So an error in that itself wouldn't be the constitutional error. Really, the constitutional error turns on the voluntariness question. So I think where Wanasik and Gunter kind of weren't very clear is when they were looking at prejudice, they were looking at it in terms of the inquiry, like had the trial court, conducted an adequate inquiry, what would have happened? And I think maybe they're doing that in those cases because in those two cases, the defendants were challenging the inquiry and not their voluntariness.
So suppose we think in this case, suppose we get to the prejudice part of it, suppose we think that the court, if it had conducted the inquiry, would or should have found him to have been involuntarily absent. Do we then get to say it's not prejudicial here because it wouldn't have mattered? Or do we not say that last piece?
So if the court were to find that the trial court's finding would have been covered in involuntary
Yeah.
absence.
Yeah.
I think at that point, there might be an argument where the harmless beyond a reasonable doubt standard might come into play, because then I think the involuntariness portion of it would be the constitutional error part of it. And so then when harmless beyond a reasonable doubt comes into play, the courts that have applied that apply it to like the outcome, right? So they look at the strength of the evidence,
Right.
whether the parts that the defendant missed had, if he had if he would have had a
Because
meaningful
I thought that
opportunity.
was the position you took in the briefing, is that we could also do that last piece. And it resonates with me on some level because the evidence against him was so strong.
Yeah.
I take the point. He's found with individualized baggies. It feels like possession with intent case.
Yes.
But that said, just speaking personally, it feels a little funny though, because if figuring out what effect a defendant's presence at trial would or would not have had feels just incredibly fuzzy to me. I'm not sure analytically, in most cases, how we would ever be able to put our finger on why his or her presence would or would not have mattered. You sort of start spitballing in the abstract, like the jury's assessing his body language the whole time. He's in theory able to inform counsel as to what people are saying or not saying. But we're just so far in the realm of speculation to do that kind of analysis. I'm struggling to see how we would ever do it. And so if that's the case, why wouldn't we draw the line earlier and just say, no, the harm has to be about the voluntariness inquiry?
And there's a possibility that it does. Again, the case law just really isn't clear on this point. There are just some jurisdictions, when they do apply the harmlessness beyond a reasonable doubt, they do look at the case as a whole to determine it. And perhaps the question just depends on, the facts of any given case, and if it's going to be easier to be able to, like you said, put your finger on it and pinpoint it. Where here it really was, for a couple reasons, which is one, that the evidence against him was overwhelming, but also the portions of the trial that he missed weren't in dispute. The question came down to whether he possessed the drugs to use them or distribute them. And the distribution portion of that testimony came from the sergeant's testimony, and the defendant was present for all of that. So here, I think you can put a finger on it to say he wasn't prejudiced because the parts that he missed weren't even in dispute. And I am out of time, so if there are any questions on the 704 issue, I'm happy to answer them, but if not, I'll just submit on the briefs.
All right, thank you.
Okay, thank you.
We'll turn back to the appellant.
Thank you, Your Honors. I'd like to touch on three things in rebuttal. First, the record was adequate. The state's absolutely wrong when it claims that the record is insufficient. Here, the motion, the arguments, and the ruling were all made on the record.
But we don't have a record of what happened, what exactly happened in that half hour, right? We don't have,
Your Honor. That's
So-
true, Your Honor.
and that's what they think the record problem is. Why are they wrong about that?
Because the state had an opportunity to list its evidence and its adequate inquiry on the record. And when the defense said there's no evidence that he has voluntarily absented himself, the state sat silent. And so if that was an insufficient record, I would be hard pressed to think of when a sufficient record could be made. I mean, does the state have to stand up and say, you're right, there's no evidence, but he's still voluntarily absent?
I mean, why don't you have some obligation to file a motion to reconstruct the record and put on an affidavit of what was or was not done? Like, you could, in theory, get defense counsel to say, hey, during that half hour, I never made the phone call. Or I did make the phone call.
Right, Your Honor, because it's the state's burden is the answer to present evidence that Mr. Marshall was voluntarily absent and it did nothing. And so the fact that it did nothing is evidence that it didn't do enough. Second, the state's waiver argument is unfounded and was never made in the briefing. So we would ask that this court decline to consider that argument, and I would also just state that Mr. Marshall did not waive the argument. Counsel did object and asked that the proceedings be paused. And third, the state ignores the fact that the thumb is placed on the scale in Mr. Marshall's favor as soon as a constitutional error has been shown. There's a presumption of prejudice, and the state needs to show that it was harmless beyond a reasonable doubt. And the state has failed to even really grapple with Chadwick or Bond in its briefing and fails to acknowledge the court's reaction to Mr. Marshall's lateness.
And how do you respond to the state's, what I took to be the state's premises that the constitutional error rests on the voluntariness inquiry? And you're just saying because there was none, therefore constitutional error is presumed?
I'm not sure that the case law goes that far, but in this case, Mr. Marshall was involuntarily absent. It would be incredibly unfair to say that he made a conscious choice to skip out on trial when everything shows that he was attempting to be there. And I also would like to push back on the idea that he was taking his sweet time while he was sitting on the shoulder of the freeway with cars going by him at high speed. He was attempting to get there, and he was working within his means to do that, and anything else is incorrect. So we would rest on the briefing for the other issue as well and ask this court to reverse. Thank you.
Thank you. Thank you for your arguments. Thank you for your briefing. We'll take this matter under advisement and issue an opinion in due course. And with that, we are adjourned today.